Hi guys, this is Rajiv. Thank you all for being here. As you have heard in the recording, when you log in that this call is being recorded, does not create attorney-client relationship, um, and it is not a substitute for one-on-one consulting, but we are doing the best we can with the information we have. Okay, as usual, I will first do the questions that were posted on the forums. Um, then I will take follow-up questions. Then I have a couple of questions that were urgent but they were not posted. So I'll take those and then any new questions. I think we'll have enough time for maybe four, five, six new questions. But I'll try to finish everybody's questions before we hang up today, okay? Let's begin with what was posted on the forums. Right now I have you in presentation mode. You guys can all hear me, um, but you can't speak. By the way, if for some reason you can't hear me or I get cut off somewhere, call our office 703 908 4800 and dial 0 for the reception and let them know that there's a problem of any kind. But don't ask them new questions. If there is a problem, just call the reception, not Arlington office. Okay, the first question is from a community member who says, I'm on E3 visa extension, but my I-140 is approved. So E3 is the sort of the rough equivalent of an H1 for Australians. Um, the question is, let's see, if I apply for E3 extension, with the approved I-140, is there any issue? Um, You see, E3 is one of those odd visas that sits in between dual intent and single intent non-immigrant visas. What does that mean? If you have a student visa application or a tourist visa and you have a green card going, they won't give you a tourist visa or student visa usually. Not always, but usually. So that's because an F1 is a single intent visa. It allows you to have only the non-immigrant intent. If, on the other hand, you have an H1, H4, L1, L2, you can have a green card going no problem. They are clearly dual intent visas. But as you know, for E3, they're saying that, and you have quoted it from the USCIS memorandum, which says an E3 classification extension may not be denied solely on the basis of approved uh, labor certification or I-140. So what does that mean? That should tell you that E3 is that weird classification where they're not quite sure where to place you, but chances are, like in fact, it is known that you will have no problem just because the I-140 is approved. Okay, so don't worry, I-140 approval does not come in the way of your E3 extension. Okay. Then, so your chances are quite good, no problem there. Your next question is, if I apply now for extension of E3 visa and the decision takes up to 90 days, what happens beyond I-94 validity date? Uh, you can definitely stay while the E3 extension is pending. There is no question about that. Whether or not you can continue working, I know that for H1s, clearly you can continue working till 240 days. There's a list of sections in that regulation, and there is a regulation that talks about ongoing validity of employment authorization for up to 240 days if a timely extension is filed. Don't quote me, but I think E3 is one of those. Have your lawyers double check it. If you are not included in that, I think you are, then you can continue to stay but stop working after the I-94 expires. You can still stay. Okay. But if your I-140 is approved, and if you, but oh, you're India born. Okay, I see. I thought you were Australia born. So you can't really file 485 until the priority date becomes good. Anyhow, so E3 extension should not be a problem. E3 240 days should apply. If it does not, double check, but you can certainly stay in the United States while you're waiting. Next question is from Anton Ivan. Green card filing. Mom, dad, sister all got green card, and have been staying in the US for past 2 years. He was over 21, so he couldn't get it. Um, He's been attending college and has a bachelor's and master's degree in engineering. Uh, F1 visa is expired, but I-20 is fine. What is the best way to get the green card? Should I get them to file Form I-130? I think you should go through the H1 route. See, the problem is the family category, what is it, 2B, is very badly backed up. It's about, I think, minimum 6-7 years backed up. So if you have a master's degree and you get a job and go through the employment-based green card, you might have it in 1 or 2 years instead of 6, 7, 8 years. Okay. So once you get your H1, then you can file Form I-130 also. So then whichever comes first, whether employment-based or family-based, you can take advantage of that. Next question is on F1 visa. F1 visa is about to expire. I need to travel to India. So you changed educational institutions, and when you are coming back, your stamping is only good for like 15-20 days. Let me just double check. I came to US Jan 2009, completed masters, got OPT, STEM OPT also. H1B was not filed. Joined another college, got CPT. That can be problematic because CPTs from the very first semester are not looked upon with favor by USCIS and ICE. They feel that a lot of these schools have become employment authorization issuing factories. So they may not like that. Can they create problem at the port of entry? Yes, they can. There's no one can guarantee that it's going to work out. You know that if you go for F1 stamping, that also is not sure. I would certainly prefer that you avoid traveling until you get the H1, and even actually after you get the H1, traveling is dicey. But because of this CPT issuing college, it makes me nervous to have you travel. So, is there a list of documents you can carry? You can carry evidence of attending classes in the second school, and if the second school is accredited, carry some evidence of that. I don't think you can carry anything else that will improve your chances. Sound Reality says I-140 is approved, I-485 pending before 180 days and got downsized. See, that's not a problem. So once you file the I-1, after the approval of the I-140, once you file the 485, even if you got laid off, once 180 days are crossed, you are entitled to your AC-21 portability. So it is not required that the job continue past I-140 approval and 485 filing. As long as it was there when you filed it and the I-140 was already approved, if you filed 485 and then got downsized, this is not a problem. Okay, and your understanding is correct. In fact, I have a lot of information on this on my blog about AC-21. I've got 10 or 12 different postings and some detailed videos that should make this issue very clear to you. You only have to provide an employment letter when RFE is sent out for your 485. Okay, and that information is correct. Victor 25, 7th year extension validity in case of perm denial. So once the 7th year extension is approved, we use the perm 365-day rule. Then the perm gets denied. Will the 7th year extension be still valid? The answer is yes. In my opinion, it will still be valid. Okay. In case the perm is denied after the 7th year extension, does the employer need to have some other perm, etc. pending? The answer is no. But if they do file the appeal against that perm denial, if they file an appeal, while the appeal is pending, which is about 3.5 years, you can continue getting extensions of your H1 past 6th or 7th year. Okay, let me make sure I got all the questions. Can the employee work legally for the 7th year period without any perm application? Yeah, that is true. And leave after the 7th year? You can. Yes, yes, absolutely. See, I've looked at the law. Once USCIS has given an extension, then if things change, taking back an extension is tricky. I don't think they will do it. I have never known them to do it. Can they technically do it? There is some argument that they could say, yeah, circumstances have changed, we can take it away. But I would argue, as long as on the date of the filing of the H1 and on the subsequent approval of the H1, I was entitled to my 7th year extension. You cannot take it back from me. Okay. Next question is, can I file I-102 along with I-130 because I don't have my I-94? The answer is yes, you can. Um, I don't know of any reason why you cannot. I would suggest that you check this with USCIS. I know that, Rosie, we've done this in the past, not exactly with the I-130, but let's say, for example, with an H1. If we had lost the I-94, we would file I-102 and I-129 together. I don't see why it cannot be done. Read the instructions on I-102. I think the instructions do tell you, and in fact, there may be a check mark that says, is this application being filed in conjunction with another application? And it used to be. I haven't seen the form for a while, but I think you should be fine filing them both together. But if you are unsure, it's not going to hurt your application. Maximum they can do is send back the I-130. But what you can do is you can double check with USCIS, see what they say. PJ Kumar, he says, my perm labor cert, the job requires masters plus one. I have a 3-year bachelor's degree and 2 years master's degree. Can I file my I-140? No. See, if it is MS plus 1, your qualifications come out to be 3 plus 2 combined only becomes equivalent to a bachelor's. It doesn't matter if you have 10 years of experience. By the language of the labor certification, you must have master's plus 1 years. Questions now says, my name is Maria Yelnikova, writing on behalf of my mother. She's been living here for about 14 years. She came on a B1, B2 visa, overstayed. Then she was supposed to get a green card through her husband, but somehow the lawyer did not file the application for her. Then her sister does have citizenship. Her husband is a permanent resident of the Americas. She never left America these 14 years. Husband doesn't want to file. Is there anything we can do? See, filing through the sister is not going to help her. One, it takes too long, 10 plus years. Second, it does not forgive her for being unlawfully present in the United States. So, unless a US citizen, son or daughter, or spouse applies for her, I don't see how she can get her green card without any problem in the United States. Bob K, it's the same repeat of the question about the E3. I don't see anything new here. I think they reposted. Then the next question is from Houston Krishna. See, if you're getting marriage certificates, it's actually better to have the maiden name of your mother. Or when you are getting affidavits of birth, it is okay to have maiden name of your mother. In everything, if maiden name was the, up until she got married, maiden name was the correct name, you should use that. Okay, so let's look at the questions. One, is it okay if they issue with the current name Lakshmi, Thula? I think they should go with Lakshmi Tara, which was the maiden name from the government office. when you get her birth certificate. Obviously, she was at that time not Lakshmi Thula but Lakshmi Tara. Okay. If they issue with birth name Lakshmi Tara, will that be an issue? I don't think so, because that's her maiden name. How about affidavit from elders? I think it should they should be using, and they can say this. They can say um, Lakshmi Tara in brackets after marriage known as Lakshmi Thula. So they can do that. Okay. Does the do we need to get the affidavit from elders notarized? Well, I think on our frequently asked questions there is a format that does not require notarization. It says something like, I hereby affirm under penalty of perjury pursuant to 8 U.S.C. 1746 that the statements made herein are true to the best of my knowledge, ability, and belief. The reason you can use that language for federal affidavits is because, being a secular country, USA does not want people to take an oath if you don't believe in oath. So you can do it through affirmation under penalty of perjury. Simple answer is it is not required for you to notarize an affidavit as long as you use the right format. And the format is there in our frequently asked questions on immigration.com. Maria Yelnikova has a follow-up. She says, oh, I forgot to add, this is about her mother being unlawfully present, married to one guy. Then she divorced her first husband back in 2001, but then she remarried, who's still a permanent resident, and he won't give her a green card. So she has 5 kids with him. So either one of the American-born children, if they have reached the age of 21, or her spouse has to apply, a U.S. citizen spouse. Otherwise, she has a problem. She would be subject to 10-year bar. She should not leave the United States until she gets her green card. J2 Lance Uppercut, who's Neil in real life, says, I've moved to Maryland. I am on J2, which does not entitle me to work. J2 does entitle you to work. I'm surprised. Where did you get that information? You can get an EAD on J2. As far as I know, we've seen hundreds and thousands of these cases. I don't know why this would be an exception. Okay. So first of all, you can get work authorization, Form I-765, and that should take care of the Social Security number issue. Jeff Korn, oh, I think I know this particular member of our community. Yeah, because he's been a member since June 2002. Almost 1,000 posts, wow. Yeah, I remember you. We've talked also before. So now you're filing your naturalization, excellent. Okay, very good. Thanks for continuing this service, of course. It's greatly appreciated. N400 based on 5 years rule. Employment-based green card. What is your opinion on disclosing traffic tickets? Especially when one doesn't even remember. You can attach a letter. You can say that there are traffic tickets that I don't remember the exact details, and you can also put down whether they were moving violations or misdemeanors, or just minor violations such as parking tickets. So it's always a good idea to disclose it and let the government do what they want to do with it. If you don't know where they are, in the FBI check, they should be able to pull out any serious problems. So usually a good idea. And you can put down the fact that when I look at the driving history, I cannot find anything, but I know there were some things. So go ahead and attach a letter or a statement. Okay. Does one need to attach additional documents such as income tax transcripts? Whatever the N400 asks for, that and only that. Okay. Is that a good idea to attach a cover letter? Sure. It is not really required, but I want you to talk about your traffic offenses. So your full name is, let's say, John L. Smith, and you've used other names. You should always give all your names. It makes it easier for them to do a security check for you. So go ahead and whatever names you use during your life, list them all. So if you used John Smith or L Smith or John L, list them all down. Okay. Even if you never provided this variation in 485, you can do it now. I don't think that's a problem. Can it become a problem for running multiple name checks? I think it's a good idea to, even if they do multiple name checks. You see, I want you to get your naturalization absolutely cleanly. There should be no doubts. So disclose everything, disclose it, over disclose it if necessary. I think you should be okay. That's the way I would do it. And anyhow, good luck, and it's great to see that you're still around. 1,000 posts, wow. You worked hard with us. Okay, next is Tom 16, currently on H1B, full-time permanent job with a multinational bank. They are going to file the green card, send the questionnaire. MS done, did unpaid OPT. By the way, OPT does not have to be paid or even full-time. OPT can definitely be unpaid. That's not a problem. No problem at all. You don't have to have paid OPT. Is it okay to mention these unpaid work experience in my POM filing? I think you should. Why not? If the question comes up, it's not a problem. You can explain it as unpaid. That's not a big deal. Can I mention my CPT work experience if you want to? Like I said, I believe CPT, I know OPT. Does not have to be paid. It can be completely unpaid. That's perfectly legal. User underscore local SK wants to know. They have some generic questions on 485 for derivative. Oh, I'm sorry. We just did a consultation this morning. SK, we actually talked about this, and if you're on the phone and something is still left over, we can talk about it. I told him that he should, F1 and 485 cannot really coexist, but no one really knows what it means that they cannot coexist. Does it mean if I have F1, I file 485, F1 is automatically gone? We don't know, so you should protect yourself, file employment authorization, file advanced parole, assume that F1 is gone, even though USCIS has never made it clear. We talked about this. All the questions were answered. Good. That'll give us more time to take new questions. Okay. MKB3. MKB says, work for employer A for the last 2 years on H1B. Employer A merged with employer B, another consulting company. They filed transfer cum extension in August first week in premium processing, but got an RFE about client letter. Client won't give letter. Excuse me guys, I need some water. Client won't give letter. So current employer is saying they can reply RFE once they get a new project, and they'll get a new client letter. See, that may not be allowed. We've had the following variations in this theme. It's interesting. So when you have an H1 filed based upon one project and one end client, and while the H1 is pending, you change clients and projects. These are the permutation combinations. One, USCIS will deny the case. They'll say, you change clients, you change projects, refile the case. Okay? That's most likely. Second variation that I have seen in our own office, they'll say, okay, you want us to approve this second case in the same application, prove to us that the first application was approvable. In other words, still provide the end client letter, still show that that was a valid project. And the third, which has happened once or twice, but not very many times, again in our office, is they approved the case based upon the second project. So three possibilities. Most likely they will ask you to refile. Meanwhile, in the backup plan, I inquired from two types of employers. First employer is a consulting company with 200 plus employees. They can file based upon an in-house project. They are asking about fees. I don't know what that means. But the bottom line is, if they're asking you to pay the H1 fees, that's probably not a good idea. Second employer, direct client, but they want me to join as soon as I get H1B transfer receipt. They are saying, yeah, if you are in legal status, you can do that. They are saying if they apply in premium processing, the charge of RFE is high. Ooh, I don't know about this second employer either, because they're asking you to join. If you are in status and you file an H1 transfer, you can join them as soon as the receipt comes. But if you are not in status, things are a little iffy. There is a informal comment from Vermont Service Center that said people whose I-94s have not expired and H1s have not been revoked, something like that, can join based upon the receipt of the H1 transfer. But if their I-94s have expired or revoked, H1s have been revoked, they cannot use the AC-21 portability receipt rule. So that's an iffy thing. I think you may not be able to join based upon the receipt. Both employers B, C, and D are doubtful, but the employer B, if they don't ask you to pay for the H1, I think would be okay. But make sure they actually have an in-house project. If they are just making one up, that's no good. In case of H1 denial, my I-94 will be expired. Do I need to go to India for H4 stamping? You can try getting it from Canada, but you'll have to be outside USA. Can I use 4 years of H1B if I wish to change status from H4 to H1 in US? Yeah, if you, whatever time remaining is left on the H1, you can reclaim it when you convert from H4 to H1 back again. Also, you will not be subject to the quota even if you go from H4 to H1 5 years down the line, because the quota only applies if you go outside USA for 1 year. If I go with employer C or D and H1 gets denied, is it possible to go to my previous employer A, which has been merged with B? It gets very complicated. I don't think so. There are there's a lot of theoretical discussion on this, but I would say the simple answer is, my opinion is, no, you cannot. Okay. Now, one question that relates to the identity of A and B. See, if A and B merged, whether that merged entity is a successor in interest of employer A, that question can only be answered if we look at the way the merger occurred and whether or not the job remains the same. So somebody will have to talk to your corporate lawyers or your employer to figure out if your employer B or the merged entity is a successor in interest of employer A. But this is a complicated situation. I would consider very seriously shooting for the H4 and coming back on H4 and then filing H1 through a company of your choice. Pandey wants to know, I understand that anyone can stay until date mentioned on the I-94 on the B1. What are the chances of rejection of visa for the next visa if anybody stays for the maximum limit of 6 months? That's not a problem. They gave you 6 months, you can stay. But if you have been staying in the United States more than you've been staying in your home country overall, or if you've been staying 6 months, 6 months, 6 months every year, they might give you some hassle in visa stamping again. But if you came once in 2 or 3 years and stayed for 6 months, I don't think that's a problem. Okay. This is again the same question on the E3 that was repeated. Um, Next question is fraud, marriage, and divorce. In summer 2007, I married an American citizen. I was on a student visa in Orlando. The marriage didn't go well, but we stayed married so that I get my green card. Um, a year later, I had a big problem with my husband. So it looks like he'd been cheating on her, but she's left for her home country, Morocco, left everything behind her. During my absence, the immigration charged me with attempt to commit a fraud. Is my marriage still valid or is it dropped? See, marriage has nothing to do with immigration charges of fraud. Um, you will have to contact your husband. Did they apply for a divorce or not? Okay. How can you find out? There are 50 states in the United States. He could have gotten a divorce in any state, depending upon the laws of the state. Um, I think you may have to get a private investigator or somebody who can check the filings and follow through. Easiest thing might be to contact your ex-husband, see if he's filed for a divorce, ask him for a divorce decree. Okay, so if you want to get married to your Moroccan boyfriend, it's a good idea to make sure that you were not married before. In most countries, bigamy, getting married twice, is a crime. So be careful with this. The only thing I can think of is some kind of a private detective, private investigator. Religious wedding ceremony in India was not registered. Court marriage in USA. Your information is correct. If a marriage is considered to be legal in India, if it's religious ceremonies and India accepts it, it will be considered to be legal in the United States. Muslim proxy marriages are the only exception. Otherwise, if a marriage is valid in the country in which it was performed, it is considered to be valid in the United States. So your question is which wedding should we use as the legal wedding, Indian or American? I think it's a good idea to mention, if you want, you can mention both. Let me make sure I understand what the context of your question is. Planning to use civil ceremony date as the marriage date. Will the religious ceremony in India present any hindrance? It should not. It should not. You can disclose them both. I think that's a good idea to disclose them both. That's the way I would do it. I'm a little concerned because I don't know all the facts of your case. Are you a U.S. citizen? Did she enter USA on a tourist visa? How is she here? All these things I don't know, and they could all be a problem. So, um, but answering the questions that you have posted, I would say yes. I don't see any problem in disclosing both weddings. Flower Girl 123 R1 expiring, green card pending. She's got an I-360 going, which is the equivalent of I-140 for R1 people. Um, you have an RFE. Um, you should not stay in the US past your 360, your I-94 expiration. You should apply for extension of your R1. Um, Question is, am I protected for up to 180 days under 245K? I don't know. I'll have to look at the law. I think it applies to R1 cases, but I have not looked at it specifically in that regard. So I really cannot tell you. I think R1 expiration, before its expiration, you should file the extension. That's what I think you should do. If I leave the US before I-94 expires, and if my 360 is denied at a later date, would showing an immigrant intent affect my next R1? It can. It can, definitely. I don't think R1 is a dual intent visa. Kalusha 2002. Oh, I'm sorry, I don't do DV lotteries. So I have no idea how this works. DV lotteries and political asylums are two areas I have never practiced in. So only one political asylum case I did back in 1992 for somebody as a favor. but I have not ever done any of these cases. DV, you don't need a lawyer. Political asylum is just not my interest. I've never done any of those. Okay. So, guys, I'm open to questions, only follow up questions first. It looks like we should have enough time for new questions. Oh, by the way, I'm sorry. I forgot. I have two or three other questions. One question is from this lady. She was married for 7 years. She was living in USA on H-1B, applied for a green card, still married. Green card got approved, but she left for India. She didn't come back. She has no APH for H-1B stamping. Green card is approved. How can I come back to collect the green card, I guess? Well, you should enter when you can, as early as possible. I don't know if there is any good options for you. Uh, See, technically, your green card should be valid because you were still married when you got your green card. But I know cases where USCIS has created problems to give green card to a derivative of an employment-based case, where the parties were just living apart. They were not divorced, but they were separated. I have always found that to be problematic because until you are actually legally divorced, you are still married. And if your husband did not um, revoke your 485, you should be allowed to keep your green card. I think the only thing I can think of, ma'am, without going into much detail, is you should contact the consulate, maybe talk with another lawyer who has a better idea of the situation. And there is something called a travel letter. Travel letter. They might be able to issue you some kind of a travel letter, which is based upon your green card approval. Sometimes when people lose their green cards when they are traveling outside, they go to the consulate and they apply for a travel letter. I've known of people in your sort of situation to apply for a travel letter. Will you be able to get a tourist visa? I doubt that. This question is from somebody who says, look, I had some problems at work and my father had to be hospitalized. There was a heart attack, but there is some kind of a performance improvement plan going on under which he is working, and if he doesn't do his job well, they'll let him go. They are concerned. The employer is concerned about his employment. He's on H-1B. So I can be, if I take leave, I'll be fired. Well, first of all, let me clarify something. As far as I understand the law, unless there's a contract, this is an issue of state law, not immigration law. You should talk to your state employment lawyer. But typically, in any at-will employment state, every state in this country is at will, as far as I know. Employer can fire you for no reason, and you can leave for no reason, but they cannot fire you for the wrong reason. So if you come into the office, you're working with me, and I say, I'm sorry, I don't have a job for you any longer, I don't have to give you any explanation. But if I say, look, I'm firing you because you're an Indian and I don't like Indians, now that's a problem. Okay? So I can't really tell you. They can let you go unless there is a contract, implied or express. This is really a matter you should address with your state employment lawyer. I can't comment about that. Your follow-up question was, if I take family leave and leave for a few weeks, and one of the other companies offers you a job, will there be any issue in filing for an H-1B transfer? You should file an H-1B transfer, but in that case, wait in India, get your H-1B transfer there, perhaps apply for a new visa, unless you already have a visa stamping. In that case, check with the consulate. I think they're going to ask you to come in for a visa stamping anyway. The law always was that if you have a visa stamping and you change employers, visa is still valid. Okay, but recently consulates have been saying they want to interview people again. So take your pick. But don't come into the United States using the old employer's visa and not join them again and try to transfer, because then they could say that that visa entry was fraudulent because you did not work for the employer through whom you are supposed to work. Okay, so guys, any follow-up questions, press *5 on your phone. Any follow-up questions? Nothing new yet. Follow-up questions. 1, 2, 3. Okay, *5. Three follow-up questions. Let's start one by one. I will start in the order in which you logged in. New Jersey, area code 732. Go ahead, please.
Yeah, hi Rajiv. It's question number 17.
17. Let's get to 17. 1 second. Uh, oh, yes, the merger and which company to go with. Okay, go ahead.
So, Rajiv, do you need to tell new employer that I got the RFE while doing network transfer with old employer?
Let's look at your situation. Is your I-94 still valid?
Yes,
Okay. Um, and you are working with the employer AB merged company.
yes.
Are your paychecks still reflecting company A or AB merged?
Company A, but they said they are going to update, the employer name as well. So I will be getting, the new paycheck with employer B. But till now, I got only the employer A name.
I think you need to tell the new employer about what's going on.
Sorry, Rajiv?
I think you should tell the new employer what is going on.
Okay,
Okay.
okay.
RFE doesn't bother me, but because you are still in the valid old H1, your I-94 is still valid. So when you transfer,
Yes.
you'll be transferring from company A's H1 over to the new company. The only question would be, is company A the same as company A plus B? Okay. So
Yes.
that's a slight issue. You can try to get around that, um, but definitely I think you should disclose it.
And suppose if we use, the employer A paycheck, in that case, do we need to tell the new employer the complete situation?
Uh, I am of the opinion that in immigration cases, you should always do full disclosure. You never know if something else is going to come up and you're going to have issues. I think it's better to disclose it. It's my opinion.
Okay, okay. And suppose employer D is ready to file my premium processing, I should go with that, right? If I get the approval, I will join
If
them as
two,
the.
two, two, two things bother me. If they ask you to pay for the H1, that would bother me. And
No, no. Now employer D is ready to file me in a premium processing with no fees.
oh, okay.
I will be only the premium charges. Uh,
Uh,
so
and
definitely,
do they
still
have
if I go,
access to the end client letter? Are they going to get an end client letter?
they they will arrange it. They said.
Okay, yeah, then go with
And
employer D. I don't see any problem with it.
and as soon as it has been transferred, right, I can leave it from employer B, right?
Because you
As
are
soon as
still,
they are
yeah,
going to
yeah.
approve.
I think you can join them. See, I prefer that people join the new employer only after the H1 approval. Because if the H1 gets denied, then you are out of status. Okay.
Yes, yes, yes.
So, but in this case, because you have all these issues with the transfer, and if the employer D is insisting you join them with a receipt, I think it's okay because you are joining off of employer A's H1 on to employer D, and you're still in status. I don't see why you cannot join on receipt.
Okay, okay. Sure. Thank you so much, Raji.
You're welcome. All right, let me go on to the next person. Uh, Also, New Jersey, area code 908. Go ahead, please.
Hey, Raji, my question is not in the list, so do you want me to?
Yeah, you're gonna have to wait. I'll get back with you.
Okay.
Okay, I'm putting your hand down. Put it up again later. Okay, 1 second. Okay, last follow-up question. Area code 919, North Carolina. Go ahead, please.
Hi, I was the one who, question number 21, please.
21. Oh, wedding ceremony in India. Many marriages. Yeah, gotcha.
Right, so it's been I-130, my wife, you asked the question, I'm a green card holder and my wife is here on H-1B.
Ah, good, good. Then it's no problem.
When I'm filing,
Then it's no problem.
so when I'm filing I-130 for her, and if I use the civil ceremony date here, I was just, I mean, because I just got to know that
Disclose
you
both.
also have marriage.
Disclose both. You should use the
Uh-huh.
earlier date, Indian date, as the marriage date, but attach a cover letter that says, because we did not know, we were not sure if Indian marriages are recognized, we also have a
Uh-huh.
civil wedding ceremony. So we've got both marriages.
Okay.
No problem.
Okay.
It's okay. It's perfectly legal to
Uh,
get married to the same person twice.
okay. Okay. And so it's okay to present the legal certificate here and not include
Absolutely.
any marriage certificate
No,
in
do
there.
both. Do affidavits as well as do both. Why not?
Oh, you mean affidavit for marriage
Yeah, why
certificate in
not?
India?
Why not?
I mean,
Why not?
okay.
Do both.
The reason I asked this question is they said if you need marriage certificate from India, we both need to go to India and come back
Sure. If
for
you
employment.
what are you talking about the civil marriage? Civil marriage was in USA or India?
Civil
US.
marriage is in US,
Yeah.
correct.
Okay. Well,
Uh,
your Indian marriage, you can just get affidavits from people who attended the marriage.
okay, okay, and
Okay.
that should
That should be sufficient.
uh,
Yes.
okay. Because I was under the impression I was not married because of the registration. My tax return, I mean, shows that status as single. Will that also raise a red flag?
If anything, it should go in your favor, I think, but I am not sure about that. And if you actually did it in good faith, what you can do is you can actually file for an amendment now if you like. Talk to your CPA.
Mm-hmm.
Talk to your CPA. You can file an amendment.
Okay, got it. Okay. If I'm unable, one follow-up question. If I'm unable to secure the affidavits in time because the dates are current and I would like to go ahead and file, is it okay if I just mention the US ceremony date as the marriage date?
No, mention both dates. Don't do that. You keep asking me the same question over and over again.
No, no, no.
Mention
I meant
both.
in the affidavit.
Mention both dates.
Uh,
File with whatever you have.
okay, but I-130 states only for one date, right, for the marriage date.
But I've told you to attach a cover letter, right?
Okay, so in that include the Indian date. Okay.
That's right.
Got it. Thank you so much, sir.
Anytime. Good luck. Okay, guys, anybody has any questions, press *5. Anybody has any questions? 6, 7, 7 people, 8 people. Okay, 9 people. All right. All right, these are the only 9 people I'll be answering. I will not take any more questions after that. So, 10 people. Okay, 11 people. Okay, then these are the 11 people. We won't do anything more than that. Okay? I'll finish up these calls. Make sure you waited very patiently. Let's start with Toronto, Ontario. I'm taking you in the order in which you logged in. Okay? Toronto, Ontario. Go ahead, please, sir. Ma'am.
Hi, I have been chosen for the DV 2014 last
Ouch.
time, and
Wrong man. Wrong man. Don't do DV, but you can ask. If I know the answer, I'll give it to you.
okay, yeah. So my number is current right now as of October 1st, and also I'm actually filing from the States because my wife is living here,
Okay.
living in the States, and so I'm wondering when my 485 is processing, am I able to travel to Toronto and back? So I'm on the H4 visa currently.
So let me try to understand what you're asking me. You are currently in USA, right?
Yeah, I have status in the USA right now, but I travel to Toronto and back for work.
Okay. So you will file your 485 while you are in USA on H4. Why would you not apply for advanced parole at the same time?
Yeah, okay. I'm planning to apply for 765 and 131 year advance parole as well.
Right. So apply for advanced parole. Uh, there is a law that applies definitely to people in routine situations. It's not really a law, it's a memorandum back in the 1980s called the Cronin Memorandum, Cronin. And that contains some of these issues. So, can I travel on H4 visa and come back and still be considered to be an H4, and my 485 would not be abandoned. If you were derivative of your wife, I would clearly say yes, no problem. But the situation is a little different here. Okay, you are not based upon your wife's application. You are filing an independent DV based application. I think you should be fine traveling on H4, but I would not guarantee it. Therefore, best to travel on AP. It comes in 90 days, I'm told. So why not wait? Okay?
Okay, great. Thank you.
You're welcome. Okay, let's take the next question. Connecticut, area code 203. Go ahead, please.
Hi Rajiv, this is the question from Akshay.
I know who you are. I know who
Can you
you
hear me, Rajiv?
are. Right, I know who you are. Go ahead.
Yeah, so this is Akshay. My question was, I'm on a performance improvement plan, and if I take a leave for family-based FMLA leave, which allows me to take leave for a couple of weeks, I know that the employer is not bound to keep me employed at any point of time, but if they just end my employment while I am on FMLA leave, is that something unfair or you know? I mean, it may not be illegal for the employer, but is it something that employers usually would not do if someone is on FMLA leave? That's
Well,
what I'm trying to understand.
Akshay, the problem is that it is beyond my area of expertise. Now we are talking about law relating to personnel, hiring, firing, employment. We're not talking about immigration law anymore. So, is it legal for somebody to be laid off on FMLA? Not a clue.
I'm sorry, what was the last thing you said? Not?
Not a clue. I have no idea. Not my field.
Okay. Okay, so I'll talk to you about the area where you are an expert. If I'm on FMLA leave, I would be on an unpaid leave of absence.
Right.
And let's say, hypothetically, that my job remains and my employer retains it until I'm back from the leave.
Right.
But if I get a job from another employer while I'm on leave and file for H1 transfer, and I may not have the pay stubs indicating full pay because I'll be on a leave of absence, which is unpaid, is there a possible problem in transferring the H1 because I'll be on FMLA leave?
First of all,
And my leave will be unpaid.
first of all, the FMLA, would it be based upon your taking care of a relative in USA or India?
It would be. I would have to travel to India.
Okay, so really you are not going to be in India while you're on FMLA, correct? I mean, you're not going to be in USA. I'm sorry, I rephrased that. You're not going to be in USA when you're on FMLA, right?
I think I'll come back. When I come
Well,
back, I
look,
would
look.
want
Here's
to
my
keep
problem.
employer.
Here's my problem with your situation. My problem is if you are claiming FMLA, who is the relative you are taking care of? That's what FMLA is based upon. And if your relative is
Right.
if your relative is in India, what are you doing in USA? And if you are in USA and hang on, if you are in USA,
Yeah.
USCIS could question that, and if they find out that the relative is in India, they will not approve that as status.
Okay. But my change of employment H1B petition, that can be filed while I'm on FMLA, right? Whether I'm in India or US.
You cannot be in US. That will not be considered to be status. But if you are in India, you don't need pay stubs anyway. By the way, if the relative was in USA and you were taking care of them in USA, I think FMLA would excuse you not having pay stubs.
Okay.
Okay?
Okay.
So that I know because we've had a situation in which a similar situation, not exactly the same, but that was not FMLA, but here the person herself was sick for almost a year. And we were still able to show that she was maintaining status because it wasn't her fault. She was hospitalized, she lost a lot of weight. And they still haven't been able to figure out what's wrong with her. So we have cases like that, and usually it's not a problem.
I see. I see. Okay.
Okay.
Yeah, because what I am not very sure is that my employment change of petition with a new employer, will that be filed while I'll be in India, or once I come back and in the very first few days it will be filed, and then at that point of time, because of FMLA,
No, I have a problem with you coming back. I have a problem with you coming back on the duration of your FMLA. It looks like a pretextual entry using a visa, and the government could take an objection to that. I would be concerned about that. Okay? I have to take my. I have to actually. I have to take my next call. There's a bunch of other people waiting. But bottom line is, I don't like the idea of you entering on the old employer's visa and not joining them back at work before you file for your transfer. Okay?
Okay.
All right. Good luck to you, sir. Bye bye.
Okay. Fine.
Cambridge, Massachusetts. Go ahead, please.
Good afternoon, Rajiv.
Good afternoon, sir.
We applied for my parents' green card
Okay.
in December of 2012. We did not at that time file for an advance parole,
Okay.
but we did request for evidence in support, there was a request for evidence in support for the birth certificates,
Okay.
and we supplied that in March of 2013.
Okay.
USCIS also informed us in August that both my parents are now potential interview waiver cases, but processing time could take around 6 months.
All right.
At this time, my parents do want to travel to India, and I was wondering what are the processing times for advance parole?
I am told about 90 days. Now, there's another thing. If you have some emergency and evidence of emergency, you might be, not every local office is doing it, but you might be able to get advance parole locally. That can be expedited to a couple of weeks.
Okay, we'll try that. Thank you.
Anytime.
Are there any restrictions on the duration of stay outside the country?
As long as the advance parole is valid, no problem.
Okay.
Okay.
And what happens to the green card application when they are not in the country?
It still goes on.
Okay. Does it get put on hold or anything of that sort?
No, that's a misunderstanding a lot of people have. It does not get put on hold.
Okay, excellent.
Okay.
And is there a process by which further processing of the green cards is transitioned to India?
Sure, it's called consular processing. You can file form I-824
I-824.
and request USCIS to convert the application to consular processing.
Okay, thanks.
All right.
And does taking this route make sense, Rajiv? Would you recommend that we do transfer to India during the time that they are there, or there is emphasis on them coming back here?
No, I prefer that you just get advance parole. It's given for 1 to 2 years. They can come and go as many times as they please. If you convert it to consular processing, it could take year and a half more, and they may not be allowed to enter USA in the meantime.
Okay. All right. Thank you. We appreciate it. Thanks.
Anytime. Good luck.
Thank you.
You're welcome. Bye-bye. Aha, my neighborhood, Washington, D.C. Go ahead, please. Washington, D.C.
Hi, this is Muzammil. Hi, Rajiv.
Hello.
I've been working in H1B from 2005.
Yes, sir.
And I got my advance parole in 2010. in 2007, but they rejected my wife's EAD in advance birth. So this on my approved 140, I applied for a new H1B, and then I went to India for stamping.
Okay.
They put me in the administrative processing.
Okay.
After 3 months, I used my advance parole to come back to US. Just a week after I came back, they said that an administrative processing has been complete. They're asking for my passport to be stamped. The problem is the client said that you have been out for 3 months, but now he's saying that I cannot let you go. Either you quit or go after 3 months.
No, but you don't have to. I don't see why you have to go. Is your wife's 485 is not yet filed, right?
Her 485 was rejected, saying that the date is not current.
Okay.
So I need to go to India for stamping so I can bring my wife in H4.
Okay. So really, the issue here is this. Can we really consider her? Let me think about this. You entered USA using advanced parole, so you are a parolee. But for purposes of USCIS, they still would consider you to. If you look at the Cronin memorandum, it talks about the fact that if you enter on parole status, we consider you to be in parole, but the moment you file for H-1B extension, you are back in H-1B. In other words, you're kind of still on H-1B, kind of, but not exactly. I personally feel that her H-4 is good. You don't have to do anything. You can write to the consulate and say, I'm sorry, I had to travel back and I've used my advanced parole, just to close the file properly. I feel that she should be fine. What you can do is, practical suggestion, call USCIS. It might take you all day to get through, but ask them, if I enter on advanced parole, is my wife, I know that I am still on H1, is my wife still considered to be on H4? Okay. I think they'll say yes.
So then she can just give her passport and then get it stamped?
Is she in India right now?
Yeah, she's in India.
I believe so. That makes life even easier. I believe so. Go ahead and
so she can just go and...
I believe so, yes.
So I don't have to go to India, right? Even though I use advanced parole and H-1B is not stamped?
I don't think so at all. I think what you can do is have your lawyers write to, or you yourself write to the US consulate and say, this is the situation. Is it okay if she comes in for H4 visa? Okay. And I think...
this H-1B is not...
I'm sorry?
This H-1B is not an extension because I applied a brand new H-1B with the same employer after like a 6-month gap after I used my advanced EAD and advanced parole.
I think it should still work. Let me think about this for a moment. No, it may not, because you never converted to H1. That changes everything. See, what happened was when you entered USA using advanced parole, you still don't have an I-94 based upon your H1. So your H1 is not fully consummated. It is still an approval, not a change of status. Okay. Now, you have another option. I think one option, of course, is to go to India. I know people who send their passports in. I'm not sure that's a legal thing to do. Or you can go to Canada or Mexico and try to get your visa stamping from there. It's going to be difficult. I see the problem because in your case, since you did not do a transfer or an extension, you don't have a valid I-94, you only have an H1 approval. So your wife cannot get an H4 until you are on H1 status. You're not on H1 status. Okay. The only way around this that I can think of is you go get your H1 visa stamping. Will you be able to do it in Canada or Mexico? I doubt it because the file is in India.
Yes.
Okay. So travel to India is the only thing that I can see happening in this case.
So if I lose a job, will that be a problem?
How long ago was your 485 filed?
Sorry, what was it?
How long ago was your 485 filed?
2007.
So you are entitled to AC-21. Find another job, do an AC-21 transfer, file another H1, reapply for the H1 visa. That's the only thing you can do.
Okay, so even though it's a client, I'm a consultant. My company holds my H1B, but client is the one who is saying no.
Because your H1 was approved based upon that client and that project.
Oh, okay.
Okay?
Yeah.
Good luck to you, sir.
Yeah, thank you, sir.
You're welcome. Bye-bye. Somebody calling from India, go ahead, please.
Yes, thanks, Rajiv. I'm Pramila Manson, and my case is with expired AP. I'm going through divorce, and I'm outside US, and green card is approved. So I have two quick questions. If my friend brings the card to me, can I use that card to travel inside, or is it illegal?
It's illegal because if you're outside USA and your advance parole expires, any advance parole that is approved in your absence would be improperly issued, in my opinion. So the answer is it would be illegal. It would be illegal in my opinion.
Okay. Okay. So, and I have another question. As per your advice, if I request travel document and also if I explain my situation, is there any problem that I get from US?
They can refuse to issue you a travel letter because they could say, well, you were already separated from your husband. I told you, right? I mentioned that before, that for some inexplicable reason, they think that being separated is as bad as being divorced for the purposes of green card. I think they are wrong, but yes, they can create a problem. I cannot predict what their response would be. But I don't see any choices. That's the only choice you have.
Do you have to call local? Do you have to go to the consulate in India, or do you have to call USCIS?
No, India.
I have to go to consulate in India.
Yeah, U.S. consulate in India.
Okay.
All right.
Okay.
Good luck, ma'am.
Thank you very much.
You're welcome. Bye-bye.
Thank you.
Okay. Another New Jersey area code 201. Go ahead, please.
Good afternoon, Rajivji. I was in touch with your office a couple of weeks before.
Okay.
My current situation is my Canada visa expired, and right now I am on visitor visa in US.
Okay.
So far, I have used first 4.5 years of my H1.
Okay.
Now my plan is if I travel back to India because my visitor visa I-94 is expiring, and my current H1B visa is expiring on 15 September 2013. Can I come back on H1 and join in a different employer?
Okay, so your question is, can I use a pre-existing H1 visa to travel back into the US and join a different employer?
Yes.
No. USCIS might consider that to be fraud.
Okay. What if my future employer files a petition before I travel from India?
Same problem. That visa should not be used for a different employer when you are not going to join the employer who first caused the H1 to be issued. It's a very strange situation. Technically, an H1 visa is not tied into a particular employer. Okay? So if you were to, let's say, leave the United States, use that employer's visa and come back for the same employer and work for them for a couple of days, and then file a change of status or transfer of H1 employer and joined another employer, then you traveled again, you could use the same visa, no problem. But if you're outside USA and you travel using one employer's visa to try to join another employer, consulate takes objection to that. And even USCIS actually. Yeah.
Coming on H1B with the current employer, work for them for a week, and then...
I would say for a week is a really bad idea. The intent should be to work a little bit longer than that. But I'm
looking for a carb to carb with my current employer to future employer. So if that works out, I think it will be a...
Yeah, give it a few weeks. I think if you give it a few weeks, it should be okay.
Okay. Maybe otherwise I'll go for a carb to carb or contract to hire.
Yeah, you can do that. I don't see any problem. As long as, but you might have to do an H1B amendment for that. But At least the visa can be used.
Okay.
Okay.
Okay. But what if I come back on after a couple of days or after the expiry of my H1 visa, which is on September 15th, I come back on visitor visa and then changing the status from visitor to H1.
Never a good idea.
While in US.
B to H1 transfer, always full of trouble.
Okay.
Because B visa is given on the basis that you are only going to visit for a short time. So never a good idea.
Or after coming back on visitor visa, can I apply? Can I get the Canada visa again and then go back to Canada, stay for some time, and then how I can come back to US on H1? Do I need to wait until new H1 approval, or?
I'm not sure how that makes any difference. You should not enter USA without a proper H1 approval if that's what you intend to do, work on H1.
Got it.
Okay.
Okay, Rajiv. Thank you very much.
You're welcome. Good luck. Okay, guys, we have last 3 questions left. Let's start with Delaware. Go ahead, please. Delaware, area code 302. Area code 302. Did I lose you? Okay.
Yes.
Yeah. Go
Hi,
ahead.
I have questions, follow-up questions on number 4. About what happens if I'm unemployed and then it's still within 180 days of my 485?
Number 4. So you are entitled to AC-21. Let's say you come to the point I-140 approved, 485 not yet pending 180 days, but you left and you remain unemployed for 12 months. After 12 months, you get a letter from USCIS saying, by the way, we are ready to adjudicate your case, provide us a current employment letter. At that point, you'll have 90 days or 87 days, however many days they give you, to provide them a job letter showing same or similar job. The fact that you are not working for 12 months is nobody's business. Are you clear? You will lose your green card. Okay?
So even if after, so let's say I'm on the 4th month, and then like you said, they've given us 90 days. So if within that date I got my green card, so should I ignore the RSE or what should I do?
Difficult question to answer. As a practical matter, I would want you to make sure you keep documentation showing the 2 jobs are same or similar. Whatever job you take next. I'll give you an interesting example. This morning I got a thank you email from a client who was in a very similar situation. A little bit different than yours, but very similar. He was working for this big employer here in Washington, D.C. I-140 approved, 485 pending, 180 days. But before the green card approval came, 2 months before that, he changed employers. Did not file AC-21, but got his green card approval. So his question was, now I'm going for my naturalization. Are they going to create a problem? I said, carry with you documentation showing the jobs were same or similar. I don't think it's going to be any issue. They're not even going to question it. See, in the beginning, they questioned a lot of these cases because even USCIS was learning. They didn't know a lot about the AC-21 laws, how to handle them, but they have gotten better at it. So he just sent me an email saying, they didn't even ask me about changing jobs and how I changed jobs 2 months before I got the green card and joined a different employer. No questions asked. Make sense?
So basically, if
any documents, I'll be in trouble. I'll lose my green card and have to send.
Okay, I'll sum it up for you in 30 seconds before I go on to the next call. The sum is very simple. One, there is no law that you remain employed for any period of time. Once the RFE comes, you must provide an employment letter, of course, a valid, genuine employment letter showing same or similar employment. If the green card gets approved beforehand, keep documentation of same or similar. You should be okay, in my opinion. Okay?
Okay.
Good luck.
Okay.
Bye-bye.
Thank you.
You're welcome. Okay, last two calls. Let's go to New Jersey, Summit, New Jersey.
Hey, Raj.
Hello?
Hello.
Yes, sir. I can hear you.
Okay. So I have two EBs, 140 approval and EB3 140 2009 approval, and recently got approved for EB2 140.
Okay.
But now I changed to employer B,
Okay.
and now my old employer just revoked the recent up to 140.
Okay.
So in case he also revoked the old, which is EB3 140
Okay.
2009 approval,
Okay.
will it create problem for my green card application with the new employer?
Okay. So really your question is, does my priority date get invalidated if two pre-existing I-140s are revoked by the old employer? The answer is no.
Okay.
Okay?
So
you still carry your priority date. The only time you lose your priority date is if USCIS revokes the I-140 for fraud.
okay, but just want to know, like, on what being the employer just revoke the I-140?
It's their right. It's their right to do so, and in fact,
okay, so they'll say I want to just revoke it. So in that case,
absolutely,
I'm fine with the priority date.
You are fine with the priority date. Yes.
Okay. And one more question about the EB3 filed application, which we filed for programmers role. But now I'm joining this company as a lead analyst and probably will be filing for EB2. So as we could change the role, will it create any problem for?
The answer is absolutely no problem. When you are dealing with a priority date transfer situation, there is no law that says the jobs have to be same or similar. That is only important for AC-21 green card transfer. Priority date can be transferred across categories, across jobs, across completely different positions. No problem.
Okay. Yeah.
All right.
Thank you very much.
You're welcome. Good luck. Last question of the day. Michigan. Go ahead, please.
Hi, Rajiv. Thank you for taking my call.
My pleasure.
It's regarding my parents' visa.
Yes, ma'am.
I'm here on OPT right now,
Mm-hmm.
and my F1 visa expired in June 2013. I have only my mom. I don't have any other sibling in India, and my dad also passed away. My mom is visiting me at a frequency of every 5 to 6 months since 2010, and she has been very particular in not exceeding her stay here in US while she visits me. But now with her health deteriorating, I was thinking of having her here with me for longer time. So what are the options that I have?
I'll take a couple of minutes and sum this up for you.
Okay.
There are situations in which F2 visa is not available or H4 visa is not available. For example, for a parent.
Mm-hmm.
In those situations, the government recognizes that still a stay in the United States may be important. In those cases, they can keep extending the tourist visa as long as you are on F1, then H1, then H4, whatever status you're on. So there is actually a provision in the law to accommodate long-term extensions of B visas. And B visas are being used in lieu of a derivative visa, which is not available because of the relationship. Yet, the situation demands that such a visa be accommodated.
Okay.
So it is
So
possible.
it does not. Sorry, go ahead.
It is at least theoretically possible to keep extending her H1 as long as you need to. I'm sorry, her B1 or B2.
B.
Yeah.
But if her visa is expiring, like her B visa is expiring in 2017.
Visa expiration has nothing to do with extension of stay.
Oh, wow.
Yeah, we have done several cases like this. In one of our cases, we have the father, diabetic father, single man of a physician's son who needs medical attention you can get in India, but who's going to put medicine in your eyes? Who's going to make sure you eat at the right time? So,
yeah, that's the point.
So for him, we've been getting extensions of tourist visa for the last, I think, 3 or 4 years. And we have other similar cases. I'm not saying it's going to work in every case, but potentially that is available. By the way,
so the key is how do you file? So my application should be that strong enough.
You should file it honestly. And you should present a good case saying, I am the only daughter. She's my only parent.
Yeah.
She's got nobody else to take care of. When she entered, there was no such plan. Then I participated in this conference call with, these lawyers in Washington, D.C. with Rajiv. And he said, oh, you could do this. And that's when we realized that we could probably request you to keep extending her tourist visa. And that's what, not tourist visa, but stay. So that's why we are requesting this, and we'll keep requesting it as long as you allow us.
So it means I have to keep extending after every 4 or 5 months.
In situations like this, ask for 1 year. They might be able to do it on an annual basis.
And make it clear upfront that I'm going to ask it as a regular activity.
Absolutely. Hide nothing. Keep it absolutely straightforward. Use Form I-539. Be truthful. Make it clear that when she entered USA, she had no such intention. When you found out this was an option, you realized this is something that would work. Make sure you make them understand she will not become a burden on the US. You can take care of her financially. Or she has money to take care of herself. As long as you clarify these things, you should be able to keep on.
Do you handle such requests? Like,
we do. I hate to charge students money, but if we do the work, we'll have to charge you. This is going to be a lot of work. You can certainly do it yourself if you like. I gave you all the hints that you need. Pretty much that's what I will be doing too.
My concern is if they reject my application, my mom's existing B2 visa will also be nullified.
No, existing B2 visa will not be nullified. That's not true.
It won't be if they... Okay.
No.
Because I was thinking if I do this process and if they reject it, I'll be in a very bad situation. I don't have anyone for her to take care.
Ma'am, we can certainly try for you. I am not going to be able to do any magic. What I just explained to you, that's what I will be doing. I'll be putting it in English and I'll be making it common sense. We don't like to play games with anybody, much less the government. We'll state the case. I think it's a good, sympathetic case. I think it should be approved.
And during this extension process, she can visit India? Or she has to be in the US?
She has to be in the US while the extension is pending. And if she visits India and comes back again, she could have problems at the CBP, at the airport, having to explain all this. Because you see, USCIS is approving it. CBP will have to be explained again what's going on. So it can become problematic. Travel is not recommended. Let her stay here as long as she needs to. Because if she travels back...
But if she gets the extension, suppose they grant her 1 year extension, then in that 1 year period, can she visit back India?
Not a good idea because CBP can give her trouble at the airport, yes.
Okay. So thank you, Rajiv, and I will probably contact your office.
It's no problem. Good luck, ma'am.
Thank you.
Bye-bye.
Yeah, thank you.
All right, folks, thank you all for being here, and I'll see you in a couple of weeks again. Bye-bye.